Okay, I'm Andrew Dutson. If you've got questions, go ahead, please feel free to ask them. Please keep them brief. And remember that there are people in Cedar City as well watching this. If they've got questions, we'll answer those. Just raise your hand and try to get my attention if I'm not looking. I'll give you a little background on myself. I've been the regional engineer since April 1st. There is?
If someone does have a question, we have a roving mic.
Okay.
If you'd like them to ask the question into the mic so the people in Cedar City can hear the question, or else have you repeat it either way.
Okay. So what I was just told, if we've got questions here, we've got a roving mic, and if nobody can hear that, then I'll repeat back the question so the people in Cedar City can hear what's being asked. So I'll give you a little background on myself. I've been in Vernal for almost 17 years. I was the assistant regional engineer up until April Fool's Day this year when my predecessor retired. I'm a native of Davis and Salt Lake counties. My roots go into rural Utah. So living there out in Vernal has been quite an experience, but a good one. I see some of you here that are from the Vernal area, particularly you two guys over there. So, or I should say Duchesne and Vernal. So, but if you've got questions, just let me know as we go. Okay. I'm going to read some of this stuff. That way I keep things straight. I don't get off topic, and because some of what I'm going to read will be on your test. The development of laws governing water rights in the western United States are different, and we've got two different kinds of laws. We've got riparian doctrine and the doctrine of prior appropriation. My wife is from New Jersey, and in New Jersey, they practice riparian water law. Many years ago, her grandpa, who was a tomato and potato farmer, came out and visited us in Vernal and asked me why we did what we did. Because where he lived, they could just go and divert whatever was in the creek and put it on their crops. And I explained to him the difference between the two. The roots of the riparian doctrine were influenced by English law, just like the slide says. So they're from old American history. The doctrine of prior appropriation is a more recent way of looking at water law, and we're going to go over a little bit how that came to be. On the East Coast, there is quite a bit more water. In the Midwest, there's obviously quite a bit more water. Here in the West, especially in Utah, where we're the second driest state, there is not very much water, as all of you have seen. Okay. The development of laws governing water rights in the western United States was markedly different than in the East. The most important reason for this was the difference in climate and geography. In the East, precipitation is relatively abundant, watercourses are numerous and generally close to areas where water is needed. In most of the West, the opposite is true. Relatively slight precipitation means fewer watercourses. This increases the necessity to divert water to areas of use. The doctrine of prior appropriation, which is currently used as the foundation of the water rights system in every Western state, developed to respond to arid conditions. Native Americans were the first appropriators. Community ditches dug by American Indians were used to divert or appropriate water in the arid Southwest. The religious and military outposts of the Spaniards also required a stable supply of water. They sometimes used the canals of Native Americans and sometimes dug their own. Thus, the Spanish and Mexican settlers who established missions, agricultural pueblos, and military posts were also early appropriators. Among the later Anglo settlers of the West, Mormons have been identified as early appropriators of water. And in this state, you've got Native Americans who were early appropriators, and we've got the Mormon pioneers who were some of the others. We also had Spaniards who came in and did a number of things. In the Vernal area, there are a lot of stories of what the Spanish did, looking for gold mines, and so we've got a lot of history there and elsewhere in the state of those three different groups of people. When the pioneers came, they began diverting water and growing crops. There was no government or laws, and so they had to kind of organize things as time went on, which led to fights. And those kind of fights still continue to happen today amongst neighbors, families, irrigation companies, municipalities, individuals. Maybe the laws and times have changed, but the fight over water is still the same. And it becomes quite a topic, or a heated topic at times. Some of the basic principles for the doctrine of a prior appropriation come from mining laws. The concept of prior appropriation of water, which developed in the California mining camps, spread to other western states as mineral discoveries led California miners to other states. A basic principle of mining law was that the miner who initially staked a claim, who is first in time, is protected in the development of the claim against other miners. His is first in right. This practice carried over to the use of water and became not only recognized as tradition, but also protected in courts of law. Do you have any questions so far? Are you guys bored yet? This is a very dry subject, so. Congress took a fundamental step in deference to state and territorial water law with the passage of the Mining Act of 1866. Under this law, Congress confirmed water rights for mining, agriculture, and other users or uses that had been acquired by private parties on public lands under local customs laws and court decrees. This result obtained even though many appropriators were trespassers on federal land. The first appropriative water rights statute was passed in California in 1872. It allowed for creation of such rights by posting at the point of diversion a document stating the intended amount of the right and its purpose of use, filing for the right in the county recorder's office where the right was located, and taking the steps necessary to perfect the right, which means to put the water to beneficial use with due diligence. So a point of diversion, if you're not familiar, is the location of where the water is diverted. It talked about where the water is used, and we call that the place of use now. So your water right has to define not only where your water is diverted, but how it's used and where it's used. Those are three very important things for a water right, as well as your priority date. We'll talk some more about that as we go. In the Desert Land Act of 1877, Congress declared that the right to use water in the western U.S. by claimants under the Act must depend upon bona fide prior appropriation. The U.S. Supreme Court held that the effect of the Desert Land Act was to sever title of the water from the public land. Congress directed that rights to use water be established under state and territorial laws, separately from land ownership claims. State governments began to realize that a central administrative system to control appropriative water rights, as well as a centralized office of record keeping for such rights, would be preferable to the haphazard administration which occurred under the early statutes. Therefore, water right law is most often regulated at a state level rather than a local or federal level. You'll see the same or a similar structure for water laws in all the western states. Where I work in Vernal, we share distribution systems, which are river creek systems, with the state of Colorado and the state of Wyoming. And so over the years, I've gotten to know their state laws. And there are a lot of similarities with Utah's, and there are a lot of differences. And where we share those two systems, we've made agreements or memorandums of understanding to adopt one another's statutes or rules of thumb or what have you in order to get water delivered from one, in this case, from Utah into Wyoming or Colorado. And so we've adapted what we do just to meet what their landowners and water users need and what ours need. We have a few other systems like that around the state, in this state, and it's kind of a area by area thing. The federal government recognizes state water law and tries to play by the same rules that we do. When you get to the Native American water rights, then it's a different story. And that's a whole other animal for a different topic for a different day. In the Uinta Basin, we have the Ute tribe, and so we have a lot of interaction with them, and their point of view and our point of view are very different. That was a very unique thing that I did not experience growing up where I did in Davis County, but after moving to the Basin, I have a different perspective on both sides of that issue. And what happens with water rights in the Uinta Basin does affect the Wasatch Front. We have a distribution system on the Duchesne River, and water from that system brings is brought here to the Wasatch Front through the Central Utah Water Project, which some of you are probably familiar with. And so what happens out there does affect you here. Please keep that in mind. I think a lot of people don't realize how much the rural areas affect the Wasatch Front. In some ways, the traditional appropriation doctrine incorporated public values. A fundamental tenet of prior appropriation law was that land and water estates were separate, and that water could be removed from its natural location and used beneficially elsewhere. This facilitated the public purpose of making an inhabitable region out of arid lands. Also, there were preferred uses under traditional appropriative law, which embodied a public sentiment that domestic, municipal, and agricultural needs should be met before water could be put to other uses. The prior appropriation doctrine as enacted in the state of Utah contains some key points. First, water must be diverted and put to beneficial use. That's very important. Second, to uphold the principle of first in time, first in right, all water rights have a priority date associated with them. As we get into management of various basins, priority date will become very important. And third, a water right can be lost by either abandonment or forfeiture. Abandonment is determined by the intent of the water user and does not require a statutory time period. A water right is lost by forfeiture if the right is not used for 7 years. The law used to state 5 years, and a number of years ago it was changed to 7. If you are a water right holder or a consultant or somebody that helps with water rights and you or your client or who you work for is worried about losing your water, then you should consider filing a non-use application. And if you've got questions on those, we'll talk about more of that later. I would recommend that rather than losing your right. It's, in some instances, you'll never be able to get back what you've lost. Okay. Water rights are distributed by priority date. A priority date is typically the date when an application or a diligence claim or whatever type of right it is was first created or the water was diverted if it's a diligence claim and first put to use. If it's a water right based on an application to appropriate, then it's typically the date that that application was made, unless the appropriator or applicant did not do their due diligence and file proof of beneficial use or an extension of time and do things in a timely manner, then the priority date may have been changed. If in researching your water rights or looking at them, you're not sure if the priority date is correct, then I would recommend going back through the records and following what happened with the application or the water right once it was first submitted to the state engineer or if it's a diligence claim, and we'll talk about those in a little while when that was first submitted. And you can follow the paper trail and see why the priority date has changed. In some reservoir basins and underground water basins, the priority date is extremely important. So the first in time, first in right means that the person who or a group or entity that has the senior water right will typically get their water first. However, if they reach the limits of their water right, then they might be reduced or cut off, and the next appropriator or other people will be able to get theirs. And sometimes that happens on river systems, on underground water basins. It's also a very important thing. So it all depends on where you live and what water system you're on. Every system's different, but the underlying laws and rules are the same. So what this gentleman asked was, were the units of time on the bottom of the graph days or years, and it appears that those are dates during the year. So from January 1st to December 31st. Here's an example. Last year on the Duchesne River system, which is in the region I work in, the availability of water dropped down to such a level that the commissioner had to cut off priority dates beyond a date that they'd ever cut off on that river as far as our records are concerned. So there were water rights being either reduced or turned off that had not been turned off in the last 50 to 60 to 70 years. It was such a bad year that he had to continue to reduce them down to that point. This year, I don't think we'll have that problem. Okay. We've got two state engineers on here. We've got Kent Jones, who you all met earlier, and the other gentleman on there is Willard Young. He was the first state engineer. His initial duties were to aid in planning, design, and construction of water storage and conveyance facilities. Since Willard Young's time, our responsibilities have increased. Kent is appointed, and so is the deputy state engineer, but the rest of us are not appointed, so we don't have quite the same classification as they do. But please be kind to us because it makes our jobs a lot easier. Do any of you have questions on the state engineer's responsibilities? Okay, the Division of Water Rights is organized into different sections. You've got the state engineer here on the chart and the deputy over to the left. The regional offices, and there are 7 of us, one here for the Utah Lake Jordan River office, and that's located in this office here in Salt Lake. The West Desert and Weber River office is also located here. Then we have a region office in Logan, Utah, Vernal, Utah, Price, Utah, Richfield, and Cedar City. In addition to the region offices, we've got a field services section which deals with the distribution of water, water well drilling, and enforcement. We have a technical services section, and they deal with studies and everything else that needs to be done in helping with water here in the state and the different offices for the state engineer, and they help with cooperative things with the federal government and other agencies. We have the applications and records section, which is a very busy section of our agency where all the applications go through and records are kept. Within that, you have the public inquiry desk, which is that first group of people when you walk into our office up here, and the front desk up there where they receive all the mail and everything else that comes in. It's a very busy part of the division. You have the dam safety section, and we inspect dams statewide. There are a few federal dams that we do not inspect that are inspected either by the Bureau of Indian Affairs or the Bureau of Reclamation. And within the dam safety section, we have a stream alteration section. That's a subsection of dam safety. And we also have an adjudication services section. And they're currently doing adjudication work here along the Wasatch Front. We have other open adjudications around the state. An adjudication, and I'm just going to go over this really briefly, is it's basically when you do an adjudication, you go into a river drainage and you do a general determination of the water rights in that drainage. And one of the first things you look at are what diligence claims are there. A diligence claim is a water right that it would be pre-statutory or something that documentation to show that water was first diverted and used prior to the year 1903. In 1903, the state water code was enacted, or the first water code was enacted. And so an adjudication goes and picks up those claims and those histories and then proceeds forward into history and looks at all the other water rights within a drainage. For example, in the Vernal office, our office was first opened as an adjudication office many, many years ago in the 1950s. And it evolved into a region office. In that area, we've been adjudicating water rights within subdrainages of the Duchesne River and in the Ashley Valley and Vernal. We're finally finishing the Ashley Valley. We've got one set of records for one canal system that goes through the middle of the valley that's left. The rest of them are finished, but it takes many years to do an adjudication. The newer system that we use now is a little bit different, and that will be discussed later. Any questions? Comments, jokes? You guys still awake? Okay. Our office is divided then into these 7 regions. The regions are divided by river drainage boundaries, with the exception of the West Desert. So if you look at this area right here, for example, whenever you hear them talk on the weather report about the Mirror Lake Highway and the snowtail sites there, this area of the western Uintas produces water for the Duchesne River, the Provo River, the Weber River, and the Bear River. There's the point of interest there. My region's over here in the red. We've got the Price region, which covers this blue area right here. The Richfield region covers this area in pink. This greenish color here is the Cedar City region. The darker blue color is the Weber River region, and the light blue up here at the top is the Logan region. these numbers that are within the different little areas here are water right areas. It's kind of like an area code system, where if you look at the area codes, you can determine from that what water right region you're dealing with. That system of water right numbering, as far as I can tell, was created in the 1960s. Prior to that, we used an application numbering system. And so when you research water rights, you'll find that there are application numbers. You might find a diligence claim number. An application number will start with a capital A. A diligence claim will start with a capital D. Sometimes you'll see certificate numbers, and those are just a sequence of numbers. And so as you research old water right records, you're going to find numbers like that at different points. As you start researching from the 1960s forward, you might still find the numbering system, but you'll also find a water right numbering system. And so that area code system was added, I would imagine, because they got to be so cumbersome statewide. When you research water rights, you'll see that we still use the application numbering system. And if you're trying to figure out where a water right came from, using that numbering system will help you see what the parentage of a water right is. So as you look at something and it starts with a capital A and gives a whole bunch of numbers, you might see at the end that there'll be lowercase letters or another sequence of numbers, and that just means that it's been segregated or separated from another water right. And so you can use that system to trace backwards and see where a water right originated. Other states use a different kind of numbering system. Sometimes if you're researching other state records, you'll find Utah water rights. I noticed as I've researched water rights in Wyoming, I'll find redundancy with our water right numbering system, and that's just so they can keep track of rights that are diverted in Utah and used in Wyoming. So if you start to look at Nevada, Idaho, Wyoming, Colorado, Arizona water rights, you might notice something like that. Okay, now we're going to go back to some things that I just talked about a minute ago. So in 1903, the legislature passed the first water laws that created water rights. So that's where we got the first code for water rights. The state engineer's office has been around since 1897. We had our first water code in 1903. So these rights that are prior to 1903 are called diligence claims. You will find them all around the state, especially in areas where the pioneers first settled. As you get to areas like where I work in the Uinta Basin, then you encounter a slightly different animal where you've got an area that couldn't be homesteaded until 1905, because most of the Uinta Basin was part of the original Uinta and Ouray Reservation. And different areas out there could not be homesteaded until 1905. So finding a water right where you can claim diligence in that area, and if you go back here to this map, I'm talking about this area here with the, with the 43 right here. That area could not be homesteaded until 1905. So finding a diligence claim there is very difficult. This thing likes to jump. As you go elsewhere in the state, you're going to find diligence claims, but that's one of the exceptions where they're very, very rare, because you couldn't homestead there till 1905. We do have diligence claims in that area, but they're very uncommon. But there are a lot of rights that are claiming that the tribe or members of the tribe had diverted that water prior to 1903. And we're still working on what to do with those rights. In 1936, the state code was amended so that underground water claims could be taken. When you look at an underground water claim document on the state engineer's file, you'll notice that it's pretty vague. And if you do that, I'd recommend that you go to the mapping records that we have so that you can see exactly where perhaps this well is located. If it was located and mapped by the state, then you'll be good to go or on your way in figuring out what to do. So underground water claims started being taken in 1936. And today, we take applications to appropriate for surface water and underground water using the same system. It's the same system statewide. Where things were disjointed before, now they've been joined together into one. Okay, Title 73 is the title or the section part of the Utah Code that deals with water and irrigation. And under that, the basic and fundamental code is that all waters in this state, whether above or under the ground, are hereby declared to be the property of the public. Beneficial use shall be the basis, the measure, and limit of all rights to water in the state. These are the different elements of a water right. First one is ownership. Who owns the water right? That can be a very greatly contested topic, or it can be very straightforward and easy. Always go to the paper records. If you look at our database and you see what's on the computer, it could be correct or it might not be. So if in doubt, go to the paper records and look. Whether you're in a region office or here in the main office looking at the master files, you should also look in the recorder's office because that is the official office of record for water right ownership. The priority date is the next part of a water right. We've talked about that already. That's typically the date when something was filed. Sometimes it's a later date if an applicant or water user didn't do their due diligence and allowed a water right to lapse and then be reinstated. Yes? Hold on a second.
If it's in the recorder's office, is it necessarily here?
No. We typically don't get records from the recorder's office unless they're brought into us and filed appropriately. We might be aware that it's changed, but we can't change our record without the proper paperwork being submitted. That's a very good question. A lot of people come into our office in Bernal and say, well, I bought this property 20 years ago or 10 years ago. Why didn't the ownership here get changed? And we'll have to tell them, look, unless you come and tell us with the documentation that it's been changed, we may not know that. Often we will if it's on a distribution system where water's regulated, but if it's for a well or a spring or something like that, we might not know right away unless we start looking at the right and do our own research. The next part of a water right is the quantity of water. That has to do with the flow rate, the volume of water. So that's the amount of water you can have. Did I answer your question?
Yes, sir.
Okay, good. Sorry, I should have asked you that. So on a water right, you're going to see that it has a flow rate, and that could be measured in cubic feet per second. Or it could have a volume or both. The volume is typically in acre feet. An acre foot of water is 1 acre of water with a foot of water on it, if you need something to visualize that. It's a lot of water. Every water right, unless it's a stock, what we would call a stock watering on stream right, is going to have, with the exception of those, you're going to have a quantity of water with either a flow rate or a volume of water. Storage is another component. If you've got a reservoir that you fill up and use to irrigate, or perhaps you've got a water right for fish culture where fish are grown, raised, or if you have a recreation reservoir or a drinking water reservoir, or it could be a stock watering reservoir, and there are many, probably hundreds of thousands of those statewide. The point of diversion then is where the water is diverted out of its natural source, whether it's the location of a well or a spring box, or where the infiltration galleries from different pipes that gather water in a spring area comes together. That would be your point of diversion. Point of diversion could also be the center line of a dam if it's built on a stream. There are points of rediversion where water is taken out of one source, diverted down, and then through a canal, let's say, and put into another river drainage. That would be a point of rediversion, and those sometimes show up on water right records. The most important part of your water right, and the thing that probably defines the value and what a water right can do, are the uses. And there are many, many uses. These are just a few examples of different water uses. Irrigation is one, domestic use, and that's typically defined as indoor use for a family. Stock watering for animals or stock, mining, municipal. You could have power generation. You could have fish culture. You could have oil and gas development, which is a very common use where I work. In the old days, domestic could mean stock watering and indoor use. So when you look at really, really old water right certificates, look at them very carefully, because it might be that when they wrote that, they said domestic or culinary. And if they said domestic and culinary, it meant typically stock watering outside and indoor use. So you have to, when you look at a water right, look very carefully at how old it is and what it says. Sure, there's a question over here. So her question is, well, here, I'll let you ask that same question on the microphone.
Oh, so when did that get clarified where domestic meant strictly domestic and didn't combine, say, stock water and other things? How far in years back?
I've seen it as far back as the early 1900s, but it's probably more in the 20s, 30s, and 40s, as I've looked at certificates where I've started to see a difference.
Okay.
But if they're early 1900s, and we have some in the diligence claims in the 1800s where I work, it can go either way. I think sometimes it depended on who wrote the document. We're pretty consistent now, a lot more, I think, than we used to be. But whenever you see that, consider the age and just look at the water right, look at the maps, look at any supporting documentation you can find that'll help you define the water right.
So are you saying, for instance, in the 1800s, a diligence claim could refer to domestic, but that actually meant also stock watering at that time,
It could have meant that,
even though it didn't explicitly state that in the diligence claim?
yes. So that's where you need to look at the maps and other documents that might be on that file to see if you might be able to get that use from it. I've seen some that were like that, where the certificate said that, and then I had to go to a proof map or other map to see if they showed where stock were watering or showed a canal or ditch and indicated that that was happening. I've had to go back and look at proofs that were submitted on behalf of that applicant to see how they define things. I would just use every bit of documentation you can find to help define it.
Okay.
Sometimes they're clear and sometimes they're not very clear. And when they're not clear, then we typically try to portray that on our database as being something that this is what the certificate says, and that's all we can do. If it's very clear, then we'll put down clearly what it is. So it's always important to go back to the written documents, go to the records. Don't just take the database to be exactly as it is. It might be correct, but it could be missing information, or it could be incorrect. And if you find that it's incorrect, please let us know and we'll fix it. The amount of use goes back to the quantity of water. The amount of use is tied to whether you have, let's say, a definitive volume on your water right. In irrigation, we have a duty. A duty could be so many acre feet per acre, and we'll talk about that here in a minute. So your water rights may be allowed to work with an early priority date, but once you meet that volume, whether it's by irrigation duty or if it has a defined volume for a municipal use, if you reach that volume early in the year, you're done. You're done for the year. The place of use is very important. That's what defines where a water right can be used. Sometimes on municipal rights, you'll see that they define a place of use by a service area. And there was some discussion about that in the legislature this year, and some of that's going to be changed going forward. Okay, water rights are defined by all the things that we've talked about. Beneficial use is the measure and limit of all water rights. If you cease beneficially using your water right and you do it for a period of 7 consecutive years, your water right could be subject to forfeiture, unless it's a tribal water right. Then the rules are different. This is just rehashing then over water right details. On a point of diversion and source, it could be a surface location. A point-to-point means, as you look at those, it could be a stock watering right that allows you to go from one point on a stream down to another or vice versa. And so when you look at those, you can see, okay, this water right's a point-to-point, it's a stock watering right. If you see that on our records, go to a map and look at the map. The map will help define the limits of that water right. We talked about springs. Drains can also be a point of diversion. If you're draining a field and capturing the water and it doesn't belong to somebody else, then perhaps you can file on it depending on the area you're in, or there might be a water right that allows you to capture that drained water and use it for something. Point of diversion on a well, then, once again, is where it's located. We talked about uses. Some uses are year-round, some are part-time. The water right's going to apply that, or the water right's going to specify that, explain it. A sole supply is an amount. When you look at a water right has certain uses, and those uses might be singular for just that water right. Or if it's a supplemental right or a right used in conjunction with other rights, it might be that one water right and 3 other water rights are used for the same uses. And a sole supply might be the individual value for that particular right. So if you had 4 water rights for irrigation for 100 acres, and each one had a sole supply of 25 acres, but could be used on the full 100 acres, then those 4 water rights would each have a value of 25 acres, but they would also be usable on the whole 100 acres. That's a really generic and basic interpretation of that. Your priority date, we talked about. Ownership, we've talked about that too. These are other examples of beneficial use. An acre foot is the definition of, or you can define it by looking at 1 acre of land with a foot of water and height on it. It's a lot of water. People sometimes ask why we use acre feet rather than gallons. If we used gallons to define water rights, our numbers would be really, really big. Okay, irrigation duty. We talked about this really briefly earlier. Irrigation duty around the state varies from river drainage to river drainage and even within river drainages. If you notice right here where this 43 is, for example, this purple area right here is the boundary for 2 river systems. Those river systems were given a duty of 3 acre-feet per acre by a federal court in 1923. Outside of that, in the green, the duty is 4 acre-feet per acre within the rest of the Duchesne River drainage. And so those water right users in that area, for example, if they're in the Lake Fork or Uinta rivers, once they irrigate from all their sources and use up to a volume of 3 acre-feet per acre, if they actually get that in a year, if they get that volume, they're done for the year. So if they reach that volume on their acre of land or 100 acres by July, then they're done irrigating for the year. If they don't reach it till later, then they can continue to irrigate as long as they're in priority and as long as the water's available. Typically on an irrigation system, a commissioner will take calls, or he might have a duty schedule. On this river, for example, on the Duchesne River, the commissioner follows a duty schedule where each water user gets so many cubic feet per second of water every day. And that schedule varies depending on the time of year and what part of the river they're on. And the schedule's set up so that as they follow that, it'll help them reach their 4 acre-foot per acre duty schedule. And typically, those users on the Duchesne will get their 4 acre-feet every year through direct flow rights that come straight out of the river and through storage rights that are stored in the various reservoirs that either they own or the Central Utah Water Conservancy District operates through that CUP project. Typically with domestic use, we define that as 0.45 acre-feet per residence. Part-time would be 0.25 acre-feet for like a cabin or a trailer hookup. Stock watering is generally defined as 0.028 acre-feet per animal. That could be per cow, cow-calf pair, per horse. If you're looking at sheep, it's 5 sheep per cow. So every equivalent livestock unit, as we would call it for stock watering, would be worth 1 cow or horse or 5 sheep or a bazillion chickens or canaries. One time I looked at a water right and this guy raised canaries. And we had to estimate how many canaries he could have per equivalent livestock unit or per cow unit. And yeah, it got a little ridiculous. Irrigation duties range from 3 to 6 acre-feet. If you go back to that map, you'll see the 6 acre-feet over here near Moab. Sorry, this mouse is a little hard to use. And then down here in the St. George area. Sure. Hold on a second. Let him bring you the microphone, please.
Quick question on the residential use. It says 0.45 acre-feet, and every year I deal with land development, and every year I have developers saying, my development is not going to use 0.45 acre-feet for an apartment complex or for a residential home. And the state is reviewing those numbers. Is that true? Is the state looking into more research? Is 0.45 acre-feet is a fair number to use for calculating indoor domestic use?
Do you want to answer that one, Kent?
No. Yeah, I mean, yes, I do want to answer that. We've actually issued a recent policy on that, saying that we think 0.45 represents a good average number that can be used, and people can be kept safe by having that amount of water. But we do recognize that there are systems that use less water than that. And by policy, we've said that if you will come in and demonstrate that you need less water than that, that's perfectly acceptable to us. But it needs to be based on scientific evidence of what you're using, and you need to be willing to measure and then report that to our office every year about what you're using. So we do allow less water than the 0.45, and that's really up to the individual systems to determine that. We think 0.45 is safe, but a different number can be used and justified, and so we just want people to be aware of that it can be something else, but you need to make sure that you've got some evidence to show why it should be that way. And we had one system that came back that was just doing a recreational subdivision system, and normally on a recreational home we use 0.25 to define that, but they had come back and actually kept measurements and showed that they needed only 0.17. So they came back and submitted that evidence to us, and we said, that's fine, that works great for us. But you need to understand that whatever number you use, that's what you're going to be restricted to for the use in an individual home. But yes, it can be allowed. So.
Okay. Does that answer your question? Okay, great. Thanks for asking that. That was a good question. And I figured he would answer it better than I could. Okay. All right, so when you look at a water right, you've got two things to consider: diversion and depletion. If it's an irrigation right, let's say with a 6 or a 4 or 5 acre feet per acre duty, you might be able to divert up to an amount that would get you to that if you're on a distribution schedule. Or if you have a water right that allows you to take 10 cubic feet per second, or 10 second feet, as sometimes people will call it, you can do that. That's your diversion amount that you take out of the point of diversion, out of the water source, and then convey or send to where you're going to use the water. The depletion is the amount that's withdrawn from that source and not returned. So if you have, let's say, an alfalfa crop and you're in the vernal area, typically we estimate the depletion for alfalfa in that area to be 34 inches per year. And that's based on flood irrigation practices. So if I were irrigating in the Ashley Valley in vernal, I could divert out my water and probably think that I'm going to take about 34 inches annually of water out of that 4 acre feet per acre I can take. So for every acre, I can put 4 feet of water. 34 inches is nearly 3 feet. So about 3 feet, 34 inches of that 4 feet of water is going to be gone and consumed by the crop. If you're filing a change application with our office to change how you're going to use water, we have to look at depletion and see what your prior uses would deplete from a system, whether it was something that would be considered 100% depletive or partially depletive. And your proposed uses then can only use up to that amount that was depleted before. As an example, in the Ashley, I'll go back to the area I work in, we have quite a few oil and gas water rights. And there are a lot of operators and oil companies that take water out. And over the last couple of years, irrigators have been leasing their water to these companies so that they can drill. And when we look at those temporary change applications that have been filed, we have to consider how many acres they've irrigated and how much water we estimate to be depleted by that irrigation. And that estimated amount is the maximum volume then that can be diverted in the lease by the oil and gas company from whatever source they're taking it from. Do you guys have any questions on that? That's a really basic explanation for diversion and depletion. Okay. So how do I get a water right? You can file an application to appropriate in any of our offices, or if you're in an outside area or want to file from an outside area, you can come into this office here in Salt Lake and file an application for the different regions. The process is the same for all of us. The policies might be different depending on what area you're in, but the procedures and the steps and how we advertise and do things is the same. A diligence claim then, if we go back to that, was an application or not an application, that's a claim to water where you're saying that water was diverted and used prior to 1903. We still accept diligence claims in different parts of the state, but you've got to have your evidence and be able to show that it actually happened. Some areas are closed to those, but others are still open. A fixed time application is similar to an application to appropriate, but it's an application that is valid for a set period of time. Fixed time applications can typically be extended, just like an application to appropriate, by filing an extension of time request. Those are pretty common where I work on the Green River. If you purchase a water right or a part of a water right, then you're going to need to show through the recorder's office what amount you got through a deed. And you're going to need to come in and update title. And if you file a change application, let's say you purchase a water right and it was taken from this source and you want to take it out of here, then you've got to file a change or an exchange application, and they're similar but a little different. And with those applications, you can typically change where something's diverted, or you can request to. You may not get granted, but you can request to change where it's diverted, how it's used, when it's used, and so forth. And you can do that with pretty much any water right. There are a few water rights out there that have stipulations on them because of court decrees or other things which may incur penalties on you for doing a change application, but I only know of a handful where I work. An exchange application allows you to take then water from, instead of taking it out of this river source here, let's say, for example, you're going to file an exchange and take it out of a well over here for a cabin. And so instead of doing a change, you do an exchange and say, I'm going to exchange, and the water that I would have taken over here is going to be released and put it into the system, and I'm going to take it out of this well over here on the mountainside, not too far away. Those are very common here on the Weber River system and the Provo River water system, and a few other places. They're very uncommon in other parts of the state. When you purchase a water right, in some instances, the water right is going to be appurtenant to the land where you've purchased the water. If you buy land and it has water, that water is probably going to be appurtenant to it unless it's irrigation shares. Sometimes people will sell water, and in that case, if they sell a water right, that severs the appurtenancy of the water right with the land where it was used. And when that happens, unless you're going to use it on the land where it was used, and whether you own the land or not, then you're going to have to file a change application to use it somewhere else and go through that process. Sure. Hold on a second. He's bringing you the microphone.
Can you repeat that?
Can you start over?
Can someone file a diligence claim on an existing water right?
You could. It depends on the area, and it depends on if you have the documentation to show that it should be a diligence claim. But there are going to be a whole bunch of factors involved. And it all depends on the area and what's gone on there in the past in the water right. So that's a detailed question would be a case by case. We have to look at that individually and not as something you'd have to bring the specifics to us, and we'd have to take a look at it and see. That same question's been asked in the region where I work, particularly in that 43 area that you see on the map, and in some instances we've been able to see that yes, a diligence claim could be accepted, and in other ones they didn't have enough documentation to substantiate it, or they weren't able to show that diligence had occurred. So does that answer your question?
Yes.
Okay, thank you. So these are different parts of the state. The yellow are the areas where things are restricted. The red is where new groundwater applications are closed. The green is open. In a closed area, a change application might be, or an exchange might be suitable to get groundwater, but it'll all depend on the particular details of your request and of the water rights that are involved that you have or in the area. In a restricted area, it's still possible, but you're limited in the amount that you can apply for and attain. So to research the water right files, you can look at electronic files. We've been trying very hard to get everything scanned and organized so that you can look at what we have in our office files and in our records. If you're not sure that the electronic files have enough, then go and look in the hard files. I'd always recommend that. There are ways on our website to go in and find where applications have been filed. There are different lists to show when things have been put out for public comment. Temporary changes, temporary applications are published on the website on lists. They're not put in local newspapers or on the legal notices website, so you can find that information there. The water right website is www.waterrights.utah.gov. Our region files outside of Salt Lake sometimes have the same amount of documents in them that the Salt Lake file does. Sometimes they have less. It just depends on the age of the water right and whether we've either had copies brought to us or we've made copies of what's in the hard file. So researching a region file may not be the complete record. You might have to look in the master file in Salt Lake. We try to keep those as the same thing, but sometimes it doesn't work out that way. Do you guys have any questions? Okay, one more.
If the region doesn't have, if the region may not have it all, and Salt Lake may not have it all, you're gonna have to research in both places.
You might have to, or if you're working through a region office, we can get the copies of what Salt Lake has. More than likely, everything that's in the master file will be scanned onto the database. And so if we don't have it in a region file, you can look at the scanned documents. If it still looks like something's missing and you're outside of the Salt Lake Wasatch Front area, then we can have somebody here go and make sure that everything's been scanned onto that file. We've made a great effort to do that, but there are some out there that are not that way. Some files that are incomplete. But as we find things, we add them. And if you notice problems, please let us know. On the website, as you work through the database, you'll see a comment section. Please feel free to put comments, gripes, other questions you have on there, or come in and talk to one of us. When you put comments in that section, James Greer, who is standing right next to you, actually gets notice of those. And if there's something we can fix or you feel like we need to fix, just let us know. Okay. Did that answer your question, sir? Okay, good.
I've got a question from Cedar City. In a closed GW system, if one water rights user loses their water right due to non-use, does the system then become open for another person in that system to pick up that water?
I don't work with any closed groundwater systems. Could you answer that one for me, Kent? I don't want to give you the wrong answer.
In a groundwater system that somebody's water right gets lost, forfeited, lost from non-use, it would depend on the size of the water right, but looking at that basin, I haven't found any basins that are closed groundwater systems that when one water right goes away, there's enough water to satisfy all of the existing rights in the system. So most basins have been over allocated based on a priority system that you get to take water according to the priority of your right. And so mostly what happens in those situations, if there is say a right that's been declared by the court to be forfeited, it just goes to the next junior user, and then they're able to take their water. But would we open the basin up again? I think if the water right was a significant size and we could show that we were not exceeding or we weren't over appropriated, there's a chance it could be opened up. But most generally, it's already been subscribed to by other approvals of other applications in those basins.
Any more questions? Comments, jokes? Do you guys need to stretch for a second? Okay, go ahead and do that. We're going to show a video next.